to talk about something that's one of my favorite things of all time. We're going to talk today about protecting the record for potential appeal. This is really, really important to me because I do a lot of appeals, and as I'm writing every appellate brief, I think, man, if we had just said this at the lower court, we'd be in such a better position right now. And it's a hard conversation to have with people that are like, when I'm like, our chances are really not that great because here's the situation. It would have been different if we had said this at the trial court level, but we didn't. And so now we're in a position where we just got to make these arguments and hope that the Court of Appeals will go for it. So how do we put things on the record at the trial court level? Well, first of all, why is it important? It's important because if it's not on the record, the Court of Appeals cannot deal with it. You can't introduce new evidence. You can't have somebody come testify at an appeal. You can't attach this document that nobody's ever seen before and say, look, it's not fair because this document exists. It has to be a document that was at least presented to the trial court. Whether the trial court, enters it into evidence or considers it or not, like at least it was presented to the court at some point at the trial court level. So if it's not on the record, the Court of Appeals doesn't get to do it. Doesn't get to review it or think about it or consider it in any of their in any of the things that they're considering on whether or not to grant your appeal. So how do we do it? It's any document that's filed with the trial court, with the Superior Court in California. So any motion, any pleadings, anything like that. But of course that leaves out a lot of stuff when you're talking about a litigation, right? You're not filing every single letter that you write with the trial court. You're not filing discovery responses or requests or any of the back and forth letters about those discovery disputes. You're not filing deposition transcripts. Those things are not in physical evidence. Those things are not on the record unless they are already attached to a motion, or unless they're entered into evidence at trial, or unless they're specifically lodged with the court. So you've got to do one of those things. You've got to attach the documents. Any document you might want the Court of Appeals to ever think about needs to be filed with the trial court. And that includes every objection. So when you're talking to the appeals court, you're asking them to look at a decision made by the trial court and to tell the trial court that they were wrong, that they made that decision wrong. If you're appealing something, you're saying the court made a mistake, fix it. And so in order to decide whether or not the court did something wrong, the lower court did something wrong, the Court of Appeals is going to have to look at the record. Okay, and so what do you want the Court of Appeals to see? They want to see that you objected, that you brought this up to the trial court, that you brought up the law, the issue, you made the argument, you told the court what was going on. You want to show that the motion was made before the court, that the court had all the evidence to review in order before it made its decision. And almost everything at the Court of Appeals is reviewed for what's called abuse of discretion. That means in order for the Court of Appeals to overturn or overrule what the trial court ruled, you've got to prove that the lower court abused its discretion. The trial court has a lot of discretion to make rulings on evidence or procedure or things that happen in trial. They're given a very broad range of discretion. They can do a lot of things, and it's mostly based on fairness. But in order to overcome it, you've got to really show that there was prejudicial error and that the court was like, I don't give a care. I almost swore in this video, sorry. I don't care what anybody says. I don't care what the law says. I don't care what you say. I want to do my thing and screw everybody else. The trial court literally has to do almost that for an abuse of discretion to be found. You've got to be able to show that the trial court looked at all the evidence on your side and said, I don't care. You probably have a point, but I don't care, and I'm going to rule the way I want to rule anyways. That's an abuse of discretion. It's a really, really hard standard to overcome, which is why you want to put as much evidence on the record as possible so that when you get to the Court of Appeals, you could say, look, I gave the trial court all these chances, and they still gave me the middle finger. Okay, so if you don't clearly object or state the reasons for your objections, it's way more difficult. It's not only the law, like the Court of Appeals can't review things that are not on the record, but it also makes it easier for them to rule in your favor, because then they've got more to work with to find that the trial court made a mistake, okay? So that means when you're bringing a motion or opposing a motion, attach all the evidence you think is necessary. I'm always very careful about, when I attach a deposition transcript to a motion or an opposition, I usually try to keep the whole deposition there. So a lot of people cut out pages of the deposition that are not referred to or that don't have evidence that's relevant. I try to keep it there because who knows, maybe you need that thing there, and if it's there on the record, then at least you can make the argument that it was before the trial court. It's better to have too much than too little. And sometimes this means actually lodging evidence with the court. It may mean like bringing those blueprints down, those big things like in the cardboard tubes. You may want to bring that down and be like, look, court, have this. And then you've got a record of it for the Court of Appeals. Maybe it means trial is over, or the case got dismissed on summary judgment, and now you've got these deposition transcripts that are not on the record. You may need to go, you just file a document that says, hey, this is evidence in this case. I'm going to lodge it with the court. And the court takes a certified copy of the deposition transcript and keeps it at the court. And now it's lodged, and now it can be part of the record. But basically, you've got to do everything you can to get as much as you can on the record. Be careful, again, without, go listen to the video on attorney declarations, but think carefully when you're writing any declaration, an attorney declaration, an expert declaration, a juror declaration especially, like make sure that those are evidentially, what's the word? They're sound, they're good evidence. Follow the evidence code. Evidentially, I don't know. Sorry. The point is, make sure that they comply with the evidence code, because if not, it's really hard to prove that the trial court abused its discretion in ruling in some way other than what the declaration states. What else do I want to say? Obviously, declarations are evidence. We've been over this. You lay the foundation. You make sure that what you're saying is supported by the evidence that you're attaching, and that the evidence you're attaching is admissible evidence. It's not objectionable. It's not hearsay. It's got a foundation, and that there are no evidentiary objections that could make it be unconsidered by the court. I'm saying all kinds of weird things today, but you get what I mean. Now, the attorney declarations can also be a way to preserve your recollection and to document what you saw and observed and felt at a hearing, at the trial, things like that. You can say, we had oral argument today. This is what I remember happening. This is what I remember saying. This is what the court ruled. And then you've got it there in case you didn't have a transcript, a deposition, or a court reporter there making a transcript of the hearing. I mean, you should have a transcriptionist. I cannot talk today. You should have a court reporter at every hearing that you think there's even the slightest chance you could lose, because you want that transcript for the record for the Court of Appeals. But if you don't have it, then you could do a declaration to kind of be like, this is what I said, this is what I remember opposing counsel said. Let opposing counsel come later and try to contradict you. Then you've got a conflicting thing that the court can at least consider, right? And you could say, make sure there's no conclusory arguments. I don't have to say all this stuff again, okay? Jury declarations I do want to talk about for a minute. These come up so after a trial, if you think there was juror misconduct and you want to appeal based on that, you've got to get something before the trial court and something on the record about what happened in the jury room that proves juror misconduct, right? So that usually comes in the form of juror declarations. And that, the way you put those on the record is with a motion for a new trial after the trial. The time limit is really tight. You've got to make sure you get out and get those juror declarations really fast. It's like 10 days. You got to have the notice for motion for a new trial on calendar. So you got to get out there. You got to get your investigator out there. Make sure that before the investigator has the juror sign the declaration, make sure you really, really check it for evidentiary issues, right? Okay, so juror declarations, just like declarations, or just like attorney declarations or expert declarations, or any evidentiary ruling that the trial court makes, is always abuse of discretion. Certain things are reviewed by the appellate court de novo, and that means de novo review means that the Court of Appeals is going to look at it with a fresh eye, as if no one's ever looked at it before. And this is good because that's what you want. That you want them to look at everything as a whole and make a decision. But what they're going to do, they're not going to take all the evidence. They're going to take only the evidence that was ruled admissible by the trial court. So the only way to get in evidence that the trial court did not consider is to prove that there was an abuse of discretion as to the evidentiary ruling itself. So if you've got a juror declaration that says, I heard so-and-so say this, now you've got a hearsay issue, and the trial court's going to say, well, that's hearsay, it's not admissible. And now you've got to go to the Court of Appeals and say, I want to prove that so-and-so said this thing in juror deliberations, which makes the which proves jury misconduct, but the trial court said that's not admissible, and so now I've got to prove that the trial court abused its discretion and that should be admissible somehow or in some way, and it's like a harder battle. So if you make it correct from the beginning and in line with the evidence code, you're going to have a much easier time at the Court of Appeals. The same thing goes for summary judgments. Evidentiary rulings made by the trial court are reviewed abuse of discretion, while the court's final ruling on the summary judgment motion is reviewed de novo. So just be aware of that when you're doing things. So look, say you go through all of trial and the court has ruled stuff inadmissible. How do you get that stuff on the record if it's never been admissible in court, if it's not attached to any specific motion, if it's not whatever? The way you do it is a motion for a new trial, or if you didn't include something in your motion like earlier in litigation, you could also do a motion for reconsideration. Neither of these are granted hardly ever. Motions for reconsideration are almost always denied unless you've got some new smoking gun evidence that the trial court is going to be like, oh, okay, maybe if we had had this, we would have ruled differently, and it's okay that you didn't have it and didn't bring it up before. And so it's very rare, but it's possible. And same with new trial motions. The court's rarely going to say, yeah, you're right, I messed up. Let's have a new trial. It sounds fun. Let's redo this whole thing. They're hardly ever going to do that. But both of these are vehicles through which you can get documents on the record that were not there before. So take advantages of those opportunities, even if you think it's kind of pointless to bring that kind of motion. I guess that's it. The thing is, more is always better. Less is more when you're actually writing, when you're using the language in the brief itself, but more is more when it comes to the evidence and the documentation that you're putting on the record. So I talked kind of a long time about that, but I feel very passionate about it, and I always want more stuff on the record. So hire your court reporters, do your declarations close in time to when things happen so that they're more believable and more accurate, and always protect the record and make it a good day.